Be seated, please. Thanks, everybody, for coming in. I think this sets a record for our biggest attendance ever. So it's an honor to have you all here. It's an honor to be here. Thanks, the Dean Audier. He and his staff have done a great job visiting with us. I think we've got a couple of business court judges here somewhere.
They were
too
at
shy. They'll be back. So this is the first day when we've had the majority of our cases or appeals from the business courts. Is this on? Am I too far away? It's all right. First time in the majority of our cases for business courts, so it's something new for us too. So we'll take arguments. It's 20 minutes per side. We'll take a 5 or 10 minute break in between arguments. Let the councils get reset. So we'll proceed directly to the. I guess I should introduce ourselves. I'm Chief Justice Scott Brister. On my right is Justice Scott Field, and left is Justice April Ferris. We will try to have enough time left over afterwards if you want to ask embarrassing questions or questions that we should have asked that we didn't to the attorneys. We'll be happy to try to take some of those from you. So first case is Kelly Hancock, acting controller of the state of Texas versus American Airlines. Who's present for the appellant? Bennett.
Rich Phillips and Mary Lee.
Good. Thank you. 20 minutes per side. You reserving anything? All right. You may proceed.
Thank you, Your Honor, and may it please the court. This is a case about preemption and what revenue a business may exclude from its Texas franchise tax report. American Airlines claims that a federal law, the Anti-Head Tax Act, allows it or preempts the Texas franchise tax as applied to certain of Americans' revenue streams, specifically those revenue streams that originate in passenger ticket sales, baggage fees, and freight transportation.
Give me a little of background on this. When did this statute come in? What's the purpose of the statute?
The Anti-Head Tax Act is from the 1980s, Your Honor. It was enacted by Congress in response to a Supreme Court of the United States ruling that was allowing counties and smaller municipalities to tax airlines to generate revenue.
And the airlines didn't like that. They ran to Congress and got an exemption.
I presume that's what happened, Your Honor.
And when did you all discover this was a taxable source out there and first decide to try to apply it as you did? Is this the first case you?
This is the first case where this issue has come up, Your Honor. In a Texas audit on the franchise tax, we don't always pursue every line that is available to the state, and it is required. The companies report what they report, but this is an issue of first impression for this court.
And it looked like in the record that the Department of Transportation had weighed in at some point. We didn't have, of course, the contents of the letter, but we had what the final ruling was. And it looked like they were in favor of American Airlines' position. Is that still the case?
To my knowledge, that's still the case, Your Honor. I don't think anyone sought an updated ruling. That letter was from quite some time ago. But the letter is wholly irrelevant to how this court resolves the case. This court can decide the preemption issue without needing to refer to what is in the record from the Department of Transportation, the Federal Department of Transportation, to be clear. So American claims that the Anti-Head Tax Act preempts certain of its revenue streams. But when Congress enacted that act, it spoke clearly. It said states may not enact a tax on the gross receipts from air commerce. It spoke equally clearly. It said states can enact franchise taxes. The ultimate question this court's going to have to answer is whether or not the Texas franchise tax is preempted by the Anti-Head Tax Act. And the answer is no, because the Texas franchise tax is not a gross receipts tax. It's a margin tax, which is more akin to a net revenue rather than a gross receipts tax.
Why can't, it seemed like to me the briefs were like two ships passing in the night. Y'all, you almost looked like y'all had different cases to me briefing them. Why can't, assume for a second that it is preempted on gross receipts and the baggage fees. Why can't the franchise tax be calculated using gross receipts from other items that American gets in revenue? I'm trying to think of an obvious example, but let's say beverages or something like that were not part of the passenger head tax, so, or other
Or maybe
revenue.
credit
that-
card.
Right, that's good.
Airport lounges, that's my favorite. Not exactly in interstate travel when you're in the airport lounge, right?
Right, Your Honor. The reason those can't be separated out is because that's not how the Texas franchise tax works. That's not what the Texas legislature set up. It's a tax on the total business of a tax-paying entity. And it starts by looking at the business done everywhere, but then it looks just at the business done in Texas. It doesn't have provisions for singling out single revenue streams. If the legislature had intended that, they would have included ways to do that.
Well, but that's good. You don't have any choice on that. We can't tax what the business is doing in Illinois, right?
Well, yes, Your Honor, that's correct. And there is provisions for that. in
So
there.
when Congress said no, it can't be based on gross receipts, they must have understood no state would try to do it for gross receipts that were somewhere else.
That was probably Congress's intent, Your Honor. But what Texas is doing is not taxing the gross receipts. They're taxing the total business done in Texas. They're taxing the margin.
How does this, can you walk me through how this case is different from Air Transport Association of New York?
Yes, Your Honor. That's the 1983 New York Appellate Division case. In that case, they called it a franchise tax.
Right.
Let's assume that it was actually a franchise tax. I don't know that it was the same as the Texas franchise tax, but they labeled it that. The problem with the tax in that case is not the label, but the way that the tax applied. It was written, let me quote from it here. Every corporation engaged in aviation shall pay a franchise tax on 75% upon gross earnings. It's a gross earnings tax, which is a gross receipts tax. And it's a simple tax at that. It's gross earnings times tax rate. It's wholly different from the way the Texas franchise tax is structured. The Texas franchise tax has a large number of steps that have to be taken to get to an amount to which a tax rate is even applied. I can walk through the steps of that, Your Honor, if you'd like,
Well,
but
but one of the steps, the one American used is total revenue times 70%, basically, right?
yes, Your Honor. And that's,
How is that different than the facts you just laid out of the New York case?
Your Honor, total revenue is not equivalent to gross earnings. Total revenue is already a netted number that it does start at gross receipts. We can't deny that. The form says, put in your gross receipts. Then you start adding and subtracting numbers. In getting from gross receipts to gross revenue and then to total revenue, you can actually wind up with a $0 total revenue because you're offsetting gains, losses, rents, dividends, interest, things like that. So right there, we're already looking at a net number, but that's beside the fact that the number coming from the gross receipts number is usually coming from an IRS tax return, and that number is also usually a net number. So we're looking at net numbers, all the way down on the Texas franchise tax.
But isn't the record here that we have in front of us, isn't Americans' calculation here truly a number with nothing netted out of it times 70%?
No, Your Honor, that's not correct.
Okay.
Uh,
Why is
they-
it not correct?
If you look at the, and it's included in the appendix, their franchise tax report, to get to that total revenue from which they deducted, they applied the 70% to, they already added in other types of income and losses. So we net it down to total revenue. And then, yes, they did take only one of the subtractions available to them, but they probably should have looked deeper and seen if they had other subtractions, which could have resulted in a lower taxable margin, which is ultimately what's taxed in Texas. For instance, the record does reflect that American had available to it, if it had done the math, maybe up to $10 billion in deductions from compensation for its employees.
And they didn't do that because you'd never tried to get tax out of them before.
Possibly, Your Honor. I don't believe that.
So they won't make that mistake again, but I'm still trying to figure out why that's not, if you start with gross receipts, I mean, the purpose of the I don't know what's it called an anti-head tax. That's
Per
kinda
head
like a
charges.
Halloween thing.
That-
So, but I don't see what that has to do with gross receipts. But anyway, suppose the idea is we don't want, I mean, this is interstate commerce. That's Congress's deal. And they don't want, just the same way we can't put tariffs on what comes in from Louisiana. They don't want people putting taxes on what flies in from Nashville. And so, but that is what, I mean, what other, I guess it may be that American Airlines has other incidental receipts, but surely the greatest majority of what their revenues are from people flying in and out, right?
Almost undeniably, Your Honor.
And so why isn't that what Congress intended to say you can't tax?
Well, they said Congress, we have to honor the plain meaning of what Congress said. They said you can't pass a gross receipts tax on air commerce, and the state has not passed a gross receipts tax on air commerce. The interstate commerce issue doesn't really come into play here because we are only looking at in-state transportation.
right.
So we're not really worried about that. But as far as
Wait a second. Are you, the receipts they put in, their franchise tax reports, is only people flying in from El Paso and Houston, or people flying in from Oklahoma City?
it should only be people flying in from El Paso and Houston. Otherwise, it would get into interstate commerce taxation issues. We do start with all the taxes. We start with the business done everywhere, which is going to snag anything done in other states as well. But we're not taxing that. That's just so we can see how much of their revenue is properly apportioned to the state of Texas. We only want to know what happened intra-state. That should be the only thing American is reporting. It's not the issue they brought before us or that we brought before you today, but that's the way it practically works. One thing that American Airlines brought up in their briefing is that the label of the tax is immaterial. And that simply cannot be true. Congress expressly provided in the Anti-Head Tax Act a section that says states can pass property taxes, net income taxes, and franchise taxes. We can't ignore the plain language of what Congress wrote, and to do otherwise would be to render the franchise tax exception superfluous. Another thing that Congress did there is called it a net income tax. The franchise tax is much closer to a net income tax than it is to a gross receipts tax for all the reasons we've talked about already. Now, Congress unhelpfully did not define franchise tax. Black's defines it. Their definition is the same as Texas' definition. It's a tax on the privilege of doing business. But luckily, the Texas Supreme Court has defined franchise tax many times for us. In 3 cases from the last 7 years, they've analyzed this issue. In Sun State, from 2019, Sun State Equipment Rentals, they said the Texas franchise tax is a tax on taxable margin, and they explicitly said it's not a tax on revenue. And this is an important distinction because the Texas franchise tax is not a revenue tax. It is not an income tax. It is not a gross receipts tax. It is a margin tax, which in tax terms is when you do a lot of calculations to get to a number that you're eventually applying a tax to. That's why I liken it to a net tax. So it's more like the net income tax that Congress has said is permitted. American has offered no alternative explanation for why Congress has exempted franchise taxes. Now, that's not to say that we could call a tax whatever we want and have it skirt by the Anti-Head Tax Act. That was one of the problems in the New York case, air transportation, and in the Aloha Airlines case from 1983 with the Supreme Court. They said that you don't just look to what the label of the tax is, you look to the purpose and effect of the tax as well. And in Aloha Airlines, Hawaii passed a 4% tax on gross income, and they specifically targeted that tax at airlines. They wrote it into the statute that this is, quote, the means of taxing the personal property of airlines. The Hawaii Supreme Court said, yeah, it's a property tax. This is fine. The U.S. Supreme Court said, not so fast, my friends. We looked at the purpose and effect of the tax, and the purpose and effect of the Hawaii tax was 4% of gross income. That is a gross receipts tax. They held it to be in a violation of the Anti-Head Tax Act.
Should the preemption question depend on the particular facts of the way a company has calculated their franchise tax? In other words, there's 2 kind of hypotheticals in my head. One is the one you've pointed out in your brief, which is use the compensation method, and that comes out to a lower amount I believe there's 4 ways you can choose. But what if a company, let's just say they're not sophisticated, so obviously this is a hypothetical, and they choose to deduct nothing from their gross receipts to get their total revenue and then choose the 70%, but they happen to be an airline. What do we do in that hypothetical? I mean, would you agree in that hypothetical, at least, it would be preempted?
No, Your Honor.
Okay.
It's either preempted or it's not preempted. And we would say that it's not preempted. In that hypothetical, the problem is that the airline did their taxes wrong. And doing your taxes wrong does not mean that the statute taxing you is invalid. It doesn't mean that it now comes within preemption. It means you probably should have hired a better tax consultant. American had subtractions available to it. They're in the statute. The trial court got that flat wrong, to be honest. As a matter of law, there are subtractions that American was required to walk through to reach their taxable margin, and they did not do so. We should not reward them for doing their taxes wrong to then say, oh, well, there were no deductions available to us. So
Is Texas unique in setting up its franchise tax like this? I mean, I was just curious why there don't seem to be any cases from other states that are closer to being on point than what we've got in front of us. Are we unique in how we're doing this?
we're not unique, but we certainly are, one of the biggest states. We're one of the only states that has a lot of intra-state air travel. I know, working for the AG's office, I've taken that Dallas to Austin flight many, many times, as I'm sure the justices have as well. So that alone, puts Texas in a unique position. Then you have to be a big state, and you have to have a franchise tax structured like this. This was just kind of a
state income tax.
And no state income tax. That's right, Your Honor. So we're kind of the perfect storm for this to come forward. And I see that my time is almost up, so I want to end with language from the Supreme Court of the United States that when a state court is looking at a question of preemption, there's a heavy presumption against preemption if there's another plausible interpretation of the statute that they're claiming is preempted. Here, we have two things that I'll point to the court. We have the language that says it has to be a gross receipts tax. Texas franchise tax is not. And we have an explicit exception allowing franchise taxes, which is what we've got here.
Thank you, Mr. Powell. Thank you. Mr. Phillips?
Thank you, Your Honor, and may it please the court. I think I'd like to start where Mr. Counts ended, which is there a plausible interpretation of the Anti-Head Tax Act, AHTA, that says that this tax is not preempted? And the answer is no. There is not a plausible interpretation that says it's not, because what do we know? It's a very simple question. Congress said you cannot tax the gross receipts of air transport or air commerce. There's no dispute that the revenue streams at issue here are receipts of air transportation and air commerce.
What do we do with the argument that, if the government says you can't tax flour, that doesn't mean that you can't tax cake? Yes, maybe that's an ingredient, but at the end of the day, the finished product is something different.
Because here, the finished product is not something different. The way that this tax is calculated for these three revenue streams, and the way that, and this is the trial court found this, there are no deductions or exclusions that apply to these revenue streams. None. None of the exclusions that can be taken out that you've heard talked about today apply to those revenue streams. There was testimony to that at trial, that by the time you get to that bottom line number, total.
What have they said is excluded that your accountants missed?
I think the only thing he's talking about, which what they've talked about in their brief, is this compensation adjustment. And I think there's some misunderstanding about that we need to clarify. The first thing is those four things you can adjust are not optionals. The taxpayer doesn't just get to pick one. You're required to use the one that results in the lowest taxable amount. So you have to do it and then pick the lowest number. For American, that is always the 70% adjustment. The only way they can make the argument about the compensation being the lower number is if you first take out the revenue streams we're complaining about. And in that situation, we don't have a problem because now they're not taxing things that are barred by the AHTA. So this idea that you have to look at compensation or that there's some sort of catch-22 for Americans just doesn't work.
What do we do with the language from the Texas Supreme Court cases, though, Multi-Cinema and and there are two others, and there is some troubling language in there about what the franchise tax is.
I think two things about that. The first one is none of those cases address this particular question. None of them were looking at whether you can look at particular revenue streams that go into the calculation to decide if they're part of a gross receipts tax. That wasn't the issue in any of those cases. I think the best way to understand it is to say, look, if the Hawaii Supreme Court had 4 cases before Aloha Airlines that said that our tax on airlines is a property tax, it's not a gross receipts tax, the Aloha Airlines case comes out exactly the same way because it is a gross receipts tax. And I heard Mr. Count say we're simply wrong when we say the label doesn't matter, but we are right because that's what the U.S. Supreme Court said. In Aloha, they said that was the argument that the state of Hawaii made. They said this is a property tax, and the statute says we can impose a property tax. And the U.S. Supreme Court said not going to work.
So why does it say gross receipts? That 70% of gross receipts is not gross receipts. It's 70% of it. So is that?
So gross receipts isn't defined in the statute. I think but I will say, and this is important, gross receipts, total revenue, even the comptroller says that they will almost always be the same thing. We cited the court in our briefing to instructions on the franchise tax thing that says your total revenue will almost always be gross receipts.
This is just a puzzle. How do we get to a situation where we have something that taxes people for millions of dollars? Nobody ever claims it. Nobody ever has it enforced. What's going on with these franchise taxes? Is this just we've got a more aggressive comptroller's office, or we're running out of money, or what?
I won't speak for the comptroller's office as to what they're doing. What I can say is this is a new position for them, right? And this is in our briefing. There was a history where we had made claims for refunds that they approved and then changed their minds. And that was when they sent the letter to the Department of Transportation and said, hey, listen, this is our interpretation. Are we right? And the letter from the Department of Transportation is not in the record.
Of course,
But the fact that they said no is.
The hidden secret is the government never waives defenses.
Correct.
They can always change their mind and say, we've been doing it this way for 50 years, but now we want the money.
Agreed. But at that point, they need to explain, I think, how it is that this is not preempted when everybody has understood that it is. In fact, again, we pointed the court to the comptroller's own decision about skydiving revenue and sales tax on skydiving revenue, which they said was preempted by the AHTA. And that by itself undercuts the idea that just because we've called it something or because it's a tax of general applicability means the AHTA doesn't apply. The idea that it has to be intentionally targeted, which I think is one of the things Mr. Council is arguing, that the tax in Hawaii was intentionally targeted at airlines, doesn't make any difference.
But what do we do with the statutory language that says franchise taxes are okay? I mean, is this an unusual way of setting up a franchise tax?
Well, I think yes. You can look at the Supreme Court's cases about the franchise tax, and there was one several years ago about whether the thing was even constitutional as presently constituted, because at the time when years ago, franchise taxes were basically pay $300 and you can be a company in our state, right? That's not hard to know what it is. And so when Congress exempted franchise taxes, that's probably what they were thinking about. Again, we don't know, but I think we have to assume that that's what they understood a franchise tax to be. But that's where you get to Aloha, where the Supreme Court said, okay, yes, it says you can do a property tax. But if your property tax is really a gross receipts tax, it's preempted. And in the New York case, the New York Air Transportation Association case, same thing. They called it a franchise tax. And the Court of Appeals in New York had no problem looking at it and saying, no, this is a gross receipts tax, and had no problem teasing out the different revenue streams, which is the other argument the comptroller's made, is that you can't figure out which inputs to take in or put out because of what we do later in the process. The New York Court of Appeals had no problem saying, no, what we're going to do is look at all these different revenue streams, and the ones that are from air transportation or air commerce, those are preempted. You don't include those in your calculation. You include the other stuff, and then you finish the calculation and you pay your tax.
Well, I was just going to ask, are you taking the position that this is a direct tax or an indirect tax on gross receipts?
Not sure that it makes a difference whether it's direct or indirect. In Aloha, they talked about that. The current language of the AHTA does not include the language about direct.
Well, and you're getting to where I was going, which is if you said it was indirect, they took the word indirect out of the statute.
And I think,
What's the significance?
I'm not sure the significance of taking it out, but I think at least one of them is we have a plain language of the AHTA. If you are taxing these revenues and you're a state, you're preempted. You can't do it. You cannot tax these revenues. And then I'll go back to Hawaii in the Kamikawa case where they've had no problem saying, you know what, you can tax the revenue, your airline, you can tax the revenues from ground transportation of freight. But, and they basically, I think, to say to the U.S. Supreme Court, we understood what you said in Aloha, we're making clear you still can't tax the receipts from air transportation of freight. So again, you can tease these things out.
How does this dovetail with, just looking at my receipt for flying up here, and it has a U.S. transportation tax in there. So is that in lieu of state taxing it?
I think, yeah, that's a tax imposed by the federal government, and therefore the AHTA has nothing to do with it.
And so attorneys, law firm fees, you have to pay a sales tax on, I guess, for services. Do we have to do that with, there's no sales tax on buying a, not that I want one, there's no sales tax on airfare?
There is no sales tax, no state sales tax on airfare. That's correct. Whether we have to pay sales tax on, there's a whole bunch of stuff on sales tax and services and goods that we don't need to get into this afternoon. But the fact is, no, there is not. And part of the purpose of the AHTA is to avoid double taxation. These things are being taxed at the federal level, and so they can't be taxed again at the state level.
So how about the, back to my airport lounge or, concessions, if you all, I can understand that, the airfare is interstate commerce. I can understand that probably the bag fees, they're moving through interstate commerce, but surely not the revenues from airport lounges. Would be other things that American Airlines would need to pay this that would not be preempted by the federal law?
Standing here, I don't know the ins and outs of every
Probably need to
line
check
on
with them
the
before you
tax,
answer that
right?
question, right?
But I think what we need to remember, I think we acknowledge there may be revenue streams that do not count as air transportation or air commerce, which is a very carefully defined term in the AHTA. And for purposes of this case, it means fee or income receipts from the transportation of people or property. Beyond that, what other things that there might be, I don't want to necessarily commit or comment to, but I agree that if it's not air transportation or air commerce, then it doesn't get excluded.
But doesn't that illustrate a problem? If you say this is preempted, how does someone at the comptroller's office is reviewing every business's franchise tax return? How do they determine that American or another airline has done it correctly? If you're accepting some revenue for certain things and calling those a head tax, but you're looking at other forms of revenue American has, and those are included, how practically would that work? And is that an argument against preemption?
I think it would work through the auditing process that the comptroller's office already has. If they have concerns about what goes into those numbers, they can go to the taxpayer and say, give us your backup. And then they can look at it. Which also brings up another point on this question of should we have done compensation deduction or the 70%? When the auditor at the comptroller's office did their audit and said we did it wrong, they didn't apply the compensation deduction. They used the 70% deduction because, or 70% adjustment. It's actually a 30% deduction, but they used that one because it's the one that results in the lowest taxable amount, and that's what's required by the statute. So I don't think the fact that the taxing entities may have to audit and go through these things has anything to do with preemption, because that's what they do. In a system where we have self-reporting of taxes, if the taxing entity has a problem, they do an audit, and then they can get behind that, and then they can decide. And that's to some extent how we end up where we are today when we said we're going to deduct these things, and the comptroller said, we're not sure you should. And so here we are.
So if you start with, your position is if you start with gross receipts, which we did start with, right?
Absolutely.
And it doesn't matter how many things you take out, it's preempted.
I think there's a good argument for that, because if the gross receipts are in there, then you're taxing gross receipts. But you don't have to go that far in our case because of finding of fact 8.
But we will in the next case.
You may. But I think in that situation, there are cases, not in Texas, but that have talked about the idea that if the amount of the tax goes up or down based on the gross receipts, then it's a gross receipts tax. And I think if you're not deducting all of the expenses that are associated with with earning that revenue, then you're still taxing gross receipts to some extent. The statute doesn't say all gross receipts. And I think that's an important distinction. But here, we have this finding that says we've got those three revenue streams. And to be clear, in the protest return that's at issue here, we included the baggage fees. We didn't include ticket sales and freight fees. But that number, and then whatever other adjustments you make all the way down to where you're going to apply the 70% adjustment, none of those deductions affects the gross receipt from those three sources, because a lot of those adjustments, and this was agreed to by the comptroller's witness at the trial, Ms. Bostic, many of those deductions have to do with things that aren't receipts in the first place. We're taking out things from your revenue that don't count, that you didn't earn it. It didn't come in. It's bad debt. It's things like that that are not gross receipts. And when Ms. Bostic was asked, both at her deposition and at the trial, when she tried to say, well, maybe there are some things that come out, what things would you say should be deducted from these gross receipts that would affect this directly? She couldn't come up with them because there isn't anything, which means, by the way, there is more than ample evidence to support that fact finding. I know the comptroller has argued that there is no evidence or insufficient evidence, but there is more than enough evidence on that, both from Mr. Smith and from Ms. Bostic on the comptroller's side. At that point, then we get to what do you do? The 70% adjustment, which we are required to take by statute, is not something that makes this not a gross receipts tax, because it's just it's effectively changing the tax rate, right? This is something, we've got this in our brief, talked about at trial. Mathematically, if you're going to do a 70% adjustment to the amount you're going to apply the tax to, you could do the same thing by reducing the tax rate by 30%. So that shouldn't have any impact at all on whether this is a gross receipts tax. The other adjustments that are made, which are argued in the state's brief, about having to adjust for apportioning what is taxable in Texas and having to decide what the tax rate is, none of those things make any difference to the analysis before the court, because that's where you're applying tax rates to the taxable amount. If that taxable amount has the gross receipts in it, then it's a gross receipts tax and it's preempted by federal law. This is not uncommon. We're not asking you to do something that hadn't been done in other states as far as figuring out that these kinds of taxes, or not necessarily this kind of tax, but certain kinds of taxes are preempted. We've already talked about the Hawaii case. There's also from Missouri, the balloons over the rainbow case, where they decided that sales taxes on balloon rides were preempted by the AHTA.
Are you aware of another case where it's truly a margins tax where this has been applied?
We've not found a case that's directly like this. I think probably our best one on this, or closest one, maybe the New York case, where they called it a franchise tax, but the court still had no problem. Again, I think the main teaching of Aloha Airlines is we are going to look and see if you're taxing gross receipts. If you're taxing gross receipts, it's preempted. And that is the end of the analysis from Aloha Airlines. The other thing I think we heard both in the brief and this afternoon is that this purpose and effect test that the comptroller purports to have found in Aloha Airlines, it doesn't, that phrase is there. It doesn't mean what the comptroller thinks it means. The comptroller would like that to mean that then you're supposed to look and see whether the legislature was intending to impose a tax that's preempted by the AHTA. That's not at all what we look at. If you look at what happened in Aloha Airlines, they didn't do any analysis of that piece of it. And they had a footnote 10 in Aloha Airlines, that acknowledged that this ruling on the AHTA would probably impact state taxes all around the country and reduce state tax revenue because they're not allowed to do this. And the Supreme Court said, yep, but that's what Congress said. And if Congress wants to change it, Congress can change it. And by the way, Congress hasn't changed it. So there's nothing in Aloha Airlines that suggests when they said purpose and effect, they meant anything other than, is this taxing gross receipts? And that's all you have to know. You can definitely tease it out. The comptroller's made an argument that we can't figure out how it applies or should it apply to these revenues. All you have to do is not put it in the number at the top, and then it's not being taxed. And that's exactly what the trial court found, and it's what this court should affirm, that these three revenue streams are preempted, and that the proper way for American to file its taxes is to take those three revenue streams out of line one and then do the rest of the process. And that is how we comply with the AHTA. Unless the court has further questions, I can go back to Mr. Miller. Thank you.
Mr. Council, 5 minutes.
Thank you, Your Honor. So why is sales tax different? It's a different style of taxation. It's a transactional tax. We're taxing each time an item is sold in the state. The franchise tax is a tax on the total business activities of a tax-paying entity. Completely different styles of taxes, and that's what happened in the 2017 skydiving case in the state of Texas, where the comptroller did agree that skydiving revenues are preempted by the AHTA. It would be kind of hard to find an example of a sales tax that isn't preempted by the AHTA, but the long and the short of it is you're buying a skydiving ride that is going up in an airplane, that's air commerce, and then you're taxing each individual flight. That's a head tax. That's the head tax part of it. Each ride counting as a taxable item.
Well, that's all gross receipts is. It's just a bunch of heads you're counting up.
And if we were just applying the tax rate to those gross receipts, I would agree with Your Honor. But we're not. We're going through all the process to reach the taxable margin. That's what the Balloons Over Missouri case from 2014 in the Missouri Supreme Court is about. It's also about a sales tax.
But there's nothing, I mean, why would you just decide, you know, what we ought to tax is 70% of somebody's gross receipts? I mean, this is just a practical thing. We don't want to take everything people are making, and we don't want to do a complicated income tax, with charitable deductions and everything else. And so, for small businesses, we'll give you a $1 million strike off, where it just eliminates small businesses having to pay the franchise tax. For law firms, where all the money goes right back out in salaries to mostly partners, but a few associates, it all goes out the door, and we don't end up having much franchise tax on law firms because that drops the revenues to almost nothing. So that was just politics. That wasn't because there's something wrong or it wasn't gross receipts. That's just what they had to do to get this tax passed, right?
Possibly, Your Honor, but
you weren't there, right?
I wasn't there. I don't know what the legislature, why it chose those particular subtractions. What I do know is what the Texas Supreme Court has said about this tax, and they've said unequivocally that it's not a revenue tax. If it's not a tax on revenue, it's hard to find that it's a tax on receipts. And we're ultimately what ends up happening in every franchise tax case, especially with a huge company like American Airlines. When we redid the audit of them, we said they should have had about $40 billion included in the revenue. They put in about $4.5 billion. But at the end of the day, the actual taxable margin is not in the billions of dollars. Both American and the comptroller found it to be in the hundreds of millions of dollars. There's a huge deduction that happens throughout the process to get down to that actual amount, to which then a fraction of a percent is applied in taxation. The tax in this case was 0.95% applied to American Airlines. It's money. It can be a good sum of money. But it's not the simple tax rate that we saw in the Hawaii case and the New York case and the other cases that we looked at, both Hawaii cases, I guess.
But doesn't that kind of yield a problem in some ways? I mean, why couldn't states then just decide, well, we know how to fix this. We'll just make a very complicated tax where you have all sorts of deductions, and as long as we have all those deductions, no preemption. I mean, isn't that a problem?
Well, Your Honor, I'm not sure that it's complicated so much as it is complex. There are a lot of steps, just like on your federal income tax return. There's a lot of steps that you have to go through.
It's still an income tax, right?
No, the Texas franchise tax is definitely not an income tax.
No, I mean your
That's
income
what
tax
everybody
return.
swears.
Yeah. I'm quoting the comptroller in the Supreme Court of this state, Your Honor. They said it's not a revenue tax. They said, Gulf Copper and American Multi-Cinema, as Justice Ferris brought up, they said this is a tax on margin. It's a tax for the privilege of doing business in Texas. It's not a transactional tax. It's not a head tax. It's not a gross receipts tax.
But in fairness to our friends up there, I mean, by the same logic, your income tax is a margin tax too. I mean, you're not taxed on your gross income. You're taxed on whatever's left over after a bunch of deductions.
And that's precisely why label doesn't matter, or does matter, or doesn't matter. Doesn't matter.
Just
We have to look.
One or the other.
Doesn't matter. We have to look at the purpose and effect of what the tax is actually doing. Not necessarily what the Texas legislature intended to do, but what it actually ends up doing. That's the analysis for the preemption. That's what the Supreme Court said in Aloha Airlines, and that's the test this court should use to reverse and render for the comptroller.
Thank you, counsel.
Case will be submitted. We'll take a 5 or 10 minute break.
Thank you.
All right. Yeah, I wouldn't have come. Those are scary things. Yeah. Yeah. And they removed one of my kids. And I was like, I've never seen someone work 2 in 1 day. Oh my God. And along with that, 10 and 1 and 11, and I probably could have gotten them 7 and 8. Yeah. You have a very strange definition of flaw. And I'm a lawyer, but that's crazy. Yep. Absolutely. We'll take a picture. All right. Thank you.
Guys, Pat, Rich, Dina. Rich, you gotta be in the middle. And Pat, you gotta be. Come on, Pat. You want to be in the picture?
You have to be in the picture
Yes,
whether you
you have
want
to be in the middle. Tall people in the middle. Yes, you right here. Tall people in the middle. Tall people in the middle.
I barely passed high school photography. Listen, he took. All rise.
Be seated, please.
All right, welcome back. Next case is Create AI Holdings versus Bot Auto Texas. Who's present for the appellant?
Good afternoon, Your Honor. Chris Bradville with Kidney Therapy and Stewart on behalf of the company.
Welcome. And for the appellee, All right, 20 minutes per side, reserve some for rebuttal.
Yes, I have, Your Honor. I believe I've reserved 5 minutes.
Okay, you may proceed.
May it please the court, Chris Cradville on behalf of the plaintiff and interlocutory appellant in this matter, Yates and I, Holdings Incorporated. So let me just very briefly start by thanking the faculty and staff of the Pennsylvania School of Law for hosting us today. It's an honor to be here, and even as a University of Texas Law School grad, I've worn the closest thing that I have to a ring.
Did notice and appreciate it.
Now, I'm glad we're here at the law school today because I'm going to use a phrase that I think is familiar to law students in this lecture hall, and that familiar phrase is hornbook case. I think this is a hornbook case of trade secret misappropriation. And I want to be forthright that we're here under a difficult standard of review. I've got a tough job really to show abuse of discretion following a 3.5 temporary injunction down in review. But I think we get there when we take seriously the mountain of circumstantial evidence that was presented to the trial court and review that mountain of circumstantial evidence through the lens of common sense. Because the backdrop of this matter is really dramatic. It's almost the platonic form of the trade secret misappropriation case. We have a technology company, my client, Create AI, which is responsible for really a world historic development. They are the first, and I believe thus far only, autonomous vehicle maker to operate a full-size semi-truck on the public streets of the United States, in this case Texas, without a human in vehicle, not as a driver, not as a safety. It's a fully autonomous operation of a 1900. That's a big deal. That's the future. And that's where this story starts. The co-founder, CEO, chief technology officer, and board of director member of my client, Create AI, a gentleman named Dr. Caltech PhD, brilliant guy, co-founded the company, helped develop this company, has so often seems to happen in the tech sector, in the startups that are making world-changing discoveries. There's a fracture at the leadership of Create AI, and Dr. Hill, he said, went to their own way, and he promptly started a new effort. The FLE here today defended below Bot Auto. And as the Transformers-based name of Bot Auto implies, they are also in the autonomous vehicle space.
Now, there's no non-competition agreement that prevented him from doing it.
We're not seeking to enforce non-compete, Your Honor. That's correct. He did sign Dr. Hay and the other departed Create AI employees, of whom there's about 30, including the executive vice president of technology, chief technologist, Mr. Wang. So two main technologists are gone. All of those employees, Dr. Hay, Mr. Wang, the other couple dozen employees who have signed in proprietary rights and invention agreement. They have agreed that anything they develop or invented while at Create AI, which is then known as Too Simple, we'll see Too Simple throughout the prior name of Create AI, that anything developed or invented there stays at Create AI. So no non-compete, but a contractual obligation to respect Create AI's intellectual property and inventions that will contribute to Create AI. So the problem we have, Your Honors, is that Dr. Ho pretty much recreated the company he left. They're not just in the same sector, which I think would broadly be defined as AI. They're not just in the same subsector, which I think would be broadly defined as autonomous vehicles. They're in the same subsector of a subsector, which is autonomous trucking with trucking as a service.
So, all of which is fine unless he took something or disclosed something that belonged to somebody else.
That's absolutely.
So my understanding is, you got, they say they put all the source code on a laptop, put it in a locked desk drawer, invited you all to come look at it, and you all chose not to.
And that's correct, because the source code is a red herring. What we're worried about is the design and architecture of certain systems within the autonomous truck.
Could you walk us through those systems? What I'm trying, and I'm not an expert on AI. My 13-year-old is much better at it
She's
than I
sitting here
am.
without a laptop. She puts everything on paper.
I do. I'm a total dinosaur. So I know that the company had about 400 patents, right? But this isn't a patent case. This is trade secret. And so can you help me kind of conceptualize what the individual trade secrets are?
That's an excellent question. You actually anticipated where I was going. I'm going to take a very specific piece of technology that we believe is a trade secret, and there was called a stipulation in the order that the parties agreed to, and that the trial court signed. It was, they don't like the term PRO, it was an agreed restraint. And it broadly restrained as a 3TI hearing scale use of 3 sets of technology, one of which is the automated safety system. So I will walk through the redundant braking system and how Create AI's dual cam fast braking system has been essentially duplicated by Create AI's successor company, by Auth. So first, let's start with, I think, some elements that are essentially uncontested here, and that's the proprietary and valuable nature of this braking technology. And I would cite the court to 8 reporters record 124, 7 reporters record 57, 7 reporters record 53, and 7 reporters record 65, all of which demonstrate efforts to realize value on the trade secrets portfolio to Create AI. I would also direct the court to 5 reporters record 288, lines 9 through 15.
So this is not helping us for oral argument. That'll help us at sometime later, but if this is in your brief. So tell me, I mean, I can totally understand if you're going to put an 18-wheeler, however many tons that is, you're going to want to have redundant systems because, if brakes don't work, there's nobody in there and you haven't trained the system to run off a truck ramp if you're in Colorado or what have you. So what is there about the dual cam, whatever?
No, before about 36 hours ago, Your Honor, I didn't know what a dual cam braking system was either. I've gotten up to speed pretty quickly. And it's the idea that there is a redundant, essentially, activator, trigger for the braking system. There are various ways you can do this. And Create AI developed this dual cam bus design. The bus is a component that activates physical cam. It takes the remote imagery, the remote data coming in and translates it into a braking event. And you want to have some redundancy there. There is testimony in the record that lots of ways you could do this redundancy. The way that Create AI did it, developed it with the dual cam bus system. And what I would specifically ask Your Honor to take a look at, because I think it shows this comparison. Start with 8 reporters record 135, page 53, and then which is the disclosure of my client's dual cam bus braking system, and then compare it to 8 reporters record 133, page 11, which is Pop Auto's analogous, we believe, derived from our system. And it's the same fundamental system design and architecture. Same fundamental system design and architecture in this critical component of the automated safety system.
But
And
isn't the problem, go back to your very intro, which I'm still hung up on, isn't the problem your standard of review? I've always, on temporary injunctions, I've always thought it's about as difficult a reversal as you can find in appellate law because of the standard of review being abuse of discretion. So, even reading the case law you cited, like Bell Helicopter, for example, those were appellate courts reviewing the denial of a temporary injunction. So, of course, they found enough evidence in the record to support that denial. Don't we have the issue that we are basically needing to look at it, the temporary injunction here, we need to look at it through the lens of whatever supports the trial court's decision.
I do not disagree with that, Your Honor, but one slight caveat. There is never discretion to get the law wrong. On at least one of these 3 elements, I believe the court already got the law wrong. So let me say that the 3 elements that I need to show abuse of discretion. First, the information at That issue is entitled to trade secret protection during the pendency of the At this TI stage, we do not need to show that it is a trade secret. We need to show that to preserve the status quo and to prevent harm, information that we say is a trade secret and that they contest as a trade secret until there's a merits adjudication, it should be treated as a trade secret. That's a relatively low bar compared to the
Well, yeah.
temporary drug.
And I'll grant you, there's 60 years of cases that say that. But Texas Supreme Court changed that in Ray State. It says the status quo doesn't matter anymore because a good lawyer can say the status quo is to do nothing. The status quo is what it was before they did something. And so you can always make the status quo that everybody's for the status quo. So the deal is who's probably going to win this case. And I understand it's a little troubling to have judges deciding who's probably going to win because sometimes we're wrong. And juries prove us wrong. But we make a guess who's probably going to win this trial, and we say to protect their rights, we don't want them to be worse off while we're waiting to go to trial and get a final judgment. So why are you probably going to win this trial that when you didn't convince two different judges that you had a trade secret here?
Believe just one judge, Your Honor, and I'm mistaken about that.
Well, it was in the district court and then went to the business court. Is this not?
Entirely the handle.
That's the other case.
Okay, that's the other case. Sorry.
No, I wanna-
See, judges are sometimes wrong.
No, judges are sometimes wrong, and I believe there is an error here for two fundamental reasons. One, I do not think the trial court engaged with mountains of circumstantial evidence. Just the facts of this case. If you were outlining what a trade secret misappropriation case looks like, it's the CEO, along with the chief technologist, along with a couple dozen of their technology employees, leaving and restarting the company in the same subsector of a subsector and using the same business model. That's what the patent is. There is not, we've presented this, we've tried to be candid with this court and the trial court, there's not a smoking gun here, but there is a mountain of circumstantial evidence. And in addition, I think trade secrets are a little bit.
I'm trying to. These are not the only two companies trying to do this. There's been hundreds of companies that have gone bust, and some of them succeeded. And bigger, huge companies that have gotten out of the market. And I mean, if those of us in Austin, it's no longer a surprise to see self-driving Waymos driving around. You see them every minute. You just get used to them. You don't notice them anymore. And while the idea of an 18-wheeler being driven driverless is a bit terrifying, for somebody that's seen as many 18-wheeler accidents as I've seen in a 20-year judicial career, it's usually driver error. So the fact of the matter is that this is something that probably would save thousands of lives and millions of dollars if we just got it done. And why should we try to stop them since they've made a lot more advance than your company did? And your company's not in the business anymore, right?
I would disagree with that, Your Honor. Our CEO testified that we are still in the business, just not in the United States. We're thinking the autonomous trucking business in Asia and overseas. So we are in the autonomous trucking business. That's the unrebutted testimony of the record, just not in the United States.
So just in China or somewhere else?
In various regional affairs, we have vehicles in Japan, 30 vehicles in Japan.
Does that undermine the imminent harm wrong?
Well, the eminent harm prong here, Your Honor, is very interesting because, and we've cited this case law in our brief, if there is a threatened disclosure of a trade secret, Texas law is you can see that is an irreparable harm. This is the easiest irreparable harm show I have ever had to make in a PRO or PI context, because unlike in any other context that I'm aware of, the law is that if there is a threat of a disclosure of a trade secret, the imminent harm is presumed, which is one of the reasons that's the legal.
So has the Texas Supreme Court ever said that?
It does not. These cases cannot go to the Supreme Court because of the interlocutory posture of the appeal, so there would have to be a consent for the Supreme Court to pick it up.
Well, there used to be. Now they take them up all the time.
Within that body of 60 years of law. That's why if you look at our brief, and my friends on the other side brief as well, almost all the citations far as the mid-level court of appeal decisions. But at the end of the day, my clients took 7 years to spend $1.4 billion to develop this technology. My friends on the other side only duplicated in a year with a $20 million investment. That's circumstantial evidence. That's why we should
But we'll give you both sides a couple extra minutes because it took up too much of your time. Thank you.
Thank you.
Ms. Alder? You may proceed.
Create AI asks this court to rule that Judge Rogan has no discretion but to grant the extraordinary relief it sought, arguing an injunction is not merely possible but mandated. Such a ruling would erode the long-standing requirement under Texas law that plaintiffs present actual evidence to obtain an injunction and would undermine credibility of determination and the fact-bound considerations that Judge Rogan made in this case. I plan to address at least 2 general points. One, Create AI failed to plead a viable Texas claim or show that it has a probable right to relief on that claim. And 2, independently, Create AI failed to provide evidence that it faces a threat of probable, imminent, and irreparable harm.
Let me ask you about the standard review on that, because the procedural nerd in me was kind of digging down on, I wanted to find a case that's actually said to reverse a temporary injunction, you have to have conclusive evidence, because some of the case law uses some evidence, the term, and I feel like we're getting into, legal and factual sufficiency. Is it your position that you have to show conclusive evidence to reverse a TI?
It's our position that they have to show some evidence, and argue the case law that the Honor does, whether that needs to be conclusive is to be determined, but they presented no evidence. So I don't think the court has proved that it was conclusive here. Their burden was to plead and prove with evidence each of the 3 elements of their testimony, and that's ownership of the trade secret, misappropriation of the secret, and damages.
Well, here,
Go ahead.
I mean, it's a circumstantial case, right? And under some of the older authorities from these intermediate courts, I mean, usually if you have a whole bunch of employees jump ship from one place to another, that can raise a big red flag. And here, we've got this novel development with AI, and it seems like we're saying, like, there's nothing to see here, AI, like, don't worry about any of this AI, can we really do that?
Nothing to see that we would understand.
Right.
Yes, lots of evidence that the 2 are fundamentally different because of
Mhm.
the form of technology that came out after Dr. Hill left. But your questions on these cases that imply a presumption of irreparable harm, when a competitor is in a position to use those trade secrets. But every single case both sides cited
Mhm.
required that the competitor have actual access to actionable trade secrets. So at this point, they don't have to prove conclusively that those trade secrets are trade secrets. They have to prove that the information is entitled to trade secret protection until the trial and merits, and they have to prove that we have actual access to them, and it's got to be improper access, which is the second prong of misappropriation. But Dr. Ho, just being the valid CEO and architect of that system, is not enough for an injunction under Texas. That's not improper acquisition of the statute. So first on the merits, on ownership of trade secrets, the very first element of its Texas claim, at least 2 problems. 1, they failed to sufficiently define the trade secrets at issue. And 2, they failed to provide evidence of any secret information that could constitute a trade secret under Texas. As to the definitions, what Create AI offers is so generic and broad that it covers technology ubiquitous to every autonomous vehicle. It amounts to sensors to see, artificial intelligence to make decisions, and redundant systems for safety.
What about this dual can? Can you help me with that?
It was an interesting explanation from something on the other side about what CAN is. I don't think any of that's in the record. Importantly, this speaks to their 3rd category of alleged trade secrets, which is the automatic safety technology. Where they have defined their trade secrets in their petition and throughout the hearing, they never mentioned CAN or dual CAN. So first, it's not identified. Second, when you drill down on the actual documents they cite for the braking system, in which Spot Auto has redundant systems for safety, and steering, which Spot Auto has redundant systems for steering, those documents are different. No witness, only 2 witnesses testified for TI cases, Dr. Ho for Spot Auto, and then Mr. Booth from Create AI. No witness was shown both of those documents. So for braking, we're looking at Exhibit 133, which is the Spot Auto document, and 135, which is the create AI documents. No witness testified between similarities or differences between those two documents.
But they're in the record, right?
They're in the record, and Free AI's position, as I understand it, is that Judge Droge was obligated to then search through the record and connect those dots for herself, and that's not what the law states. They bore the burden to connect those dots for her. They could have asked Dr. Rojas to create AI documents for breaking voice hearing. They chose not to. Further, they didn't rebut Dr. Ho's clear testimony when he was shown the bot auto breaking and steering document. This document contains no create AI information or trade secrets. That was never rebutted. The only testimony is not evidence because it's just from Mr. McCarthy, the trial counsel, who is not sworn and can't offer evidence. At the very end, Dr. Ho testified first, and then Mr. Liu. Mr. Liu also more problems with these documents they had creation. Never translated the Chinese on the spec document, and also didn't explain why it says, quote, it's the property of Too Simple LCC. That's a different entity than the plaintiff in the penalty hearing. So to the extent they relied on Judge Droge to connect these dots for herself, she couldn't. So under the lens of deferential review, we think, especially on such technical questions, Judge Droge will be well within her discretion to credit Dr. Ho's testimony.
So if you're working for somebody, they're paying you a big salary or, stock options or whatever, and you develop all this architecture and structure and design, that belongs to your employer, right? You don't get to keep that.
It depends here. There was an EPIIA in place, so yes, but that does not result in a CUTSA claim. Several cases, CAE case out of the Fifth Circuit, they fully CUTSA claim and burned the denial of an injunction. It had an eviction agreement in place. Doesn't make a
So
claim.
draw the line. We've got the exception for general background knowledge. You can take that with you, but things specifically paid for by your employer and developed that weren't general knowledge. And obviously, this was, you don't contest that this was carefully kept secret.
We do, Your Honor. We concede that some measures were taken to keep it secret. We contest and dispute whether those were reasonable under the circumstances, but our true fight is what you just hit on. They're not secret. Mr. Liu, their CEO, testified to this direct overlap between the three categories of alleged trade secrets and their hundreds of patents. So we view that as the statute says that's a threshold burden that they must distinguish between the two. Otherwise, we are left not knowing what we're accused of misappropriating, and the court's left to figure it out for itself.
They
So
say,
that's a choice.
I'm
Sorry.
sorry, they say the burden's on you.
Yeah, and they're wrong. We bore no burden at the trial court level. We bear no burden on appeal. And there are several cases in the injunction context. I'll point you first to the St. Jude, but also the Ramsey case. That's a federal and a state case. Looking at CUTSA, holding plaintiffs' feet to the fire, their burden to separate the two. What's public, what's not. The two requirements as to what can be a trade secret under CUTSA are both aimed at secrecy. One of the biggest differences between the common law trade secret claims and CUTSA. They strengthen what must be secret. And here it's
But
not
it does sound like an affirmative defense. You've got to show it's got some economic value, it's economically valuable, and that you've kept it secret. It doesn't say, and if your defense, it seems to me it's a defense to say, well, you told your mother and your brother-in-law and people on a encrypted chat somewhere, and so that's, if you've got any evidence of that, you need to trot that out. But that's not normally, you would think, the movement's burden.
First, I don't think the court needs to reach here for all the reasons that they lose before we get there. But I think you're referring to that injection research case from 1998, the Federal Circuit case. And they did hold that eventually it's an affirmative defense if the plaintiff first puts forward a prima facie evidence of a trade secret claim, which they haven't done. And then second, even if the court were to choose to apply that presumption, it's a rebuttable presumption. And here, Botado put on loads of evidence, first about their pivot, as the court mentioned earlier, from AV manufacturing to video games. And those are two different entities. Too Simple China, that's why I pointed out the property of in those documents. That's a different entity from the plaintiff and account. So the definitions were overly broad. They cover technology ubiquitous to every autonomous vehicle. Some vehicles that we even drive, they all have sensors to speak. But secondly, and most importantly, a trade secret must be secret. In many cases, plainly state. Information disclosed in patents is no longer secret. Justice Ferris, I think you were referencing earlier that yes, companies make this conscious choice to protect their technology, either through trade secrets or patents. Here, Create AI has made a conscious choice to protect its information with patents. They highlight this as a benefit of their business when they attempt to sell it in trade.
Can you tell me where, I'm just trying to fit the pieces in the buckets. So one of the areas of potential trade secret was the CNN versus TNN. Is that something that patent plays into or no? Oh,
That's a good question.
Okay.
Because they have not met this minimum threshold to separate.
All right.
I'm not sure where the patents, if they cover any aspect of the convolutional neural network, but you touched on the difference, because
Yeah.
ours is now based on something completely different. Similar to
Mhm.
what ChatGPT is built on, a transformer neural network that became publicly available and usable in late 2022, right after Dr. Ho was terminated in October 30th. So that speaks to the second bucket of their alleged trade secrets. We've got the suite of sensors.
That's the decision-making technology, right? Okay.
And because the sensors differ, also the decision-making difference. So they're putting different sensors on different trucks, and they also input the information differently. They receive the information differently. They must receive 2D information and then 3D information, and use sensor fusions to then make that an input. The transformer neural network just, it's as if it can speak every language. Every input is an input, so it's instantaneous. That's why when the failure to define is then seen in every instance. It follows throughout.
Is it a problem if maybe the earlier technology was used to develop the later better technology, or is that not?
To the extent it is, Your Honor, that faulty know-how, there's no evidence that Dr. Ho piggybacked in any way based on what was learned or built at Create AI. He testified to the exact opposite, which is that he saw the problems of the Create AI system, which required thousands of miles logged in mapping vehicles, hundreds of thousands of human hours literally drawing a box around what the bicycle was a person. And so when he saw the transformer technology come out in late 2022, he knew the potential, and he built a completely different system. No one rebutted that testimony. No one could come close to rebutting that testimony because he was the only expert on AI in the customer. So the record, I think we've highlighted the two places where Mr. Liu testified to this overlap and this failure to distinguish. I would also point the court to Exhibit 36. It's a PowerPoint in which they brag about the extensive portfolio that, quote, spans across the entire autonomous trucking ecosystem. So at a minimum, Create AI spends a lot of time quibbling over this level of specificity required in defining trade secrets, but we again would point the court to the statute. At a minimum, it requires them to separate between the two. To the extent that burden is heavy in this case, it's because of their choice to patent all of their technology surrounding AV trucking, hundreds of patents, hundreds of patent applications. As the Trilogy software case pointed out, it is the burden of the party claiming secrecy status to prove secrecy.
I think this is probably outside the record, but is there any patent litigation on?
There is, Your Honor,
Okay.
they have now sued for patent infringement. That's a public record, the court can search. Courts have consistently rejected such a claim when the plaintiff failed to meet this minimum standard of separating trade secrets from information in the public domain. We cited several cases on this in our brief. Topstone, FMC Technologies, St. Jude, and even the Verican case Create AI group sites hold to the same proposition. So it wasn't absolutely pled, it wasn't supported with evidence. And now we'll turn to the second prong of the Tutsa merits inquiry, which is misappropriation. Under Tutsa, misappropriation can be shown with evidence of improper acquisition or unauthorized use by a person who improperly acquired it. In this case, there's no evidence of either. Dr. Ho's former tenure as CEO and founder of Create AI does not prove improper acquisition. Almost every case the parties rely on has evidence of this critical element. The defendant had actual access to actionable trade secrets. You cannot prove a probable Tutsa claim about it.
Well, here didn't he have access to basically everything, and we're just trying to figure out if there's a trade secret in there.
He had prior access to everything. These cases required current access. So the CAE case and the St. Jude case looked at this pretty specifically. You cannot enjoin someone for what they used to have access to. You need current access. And that's what the cases have required such a plaintiff to prove. This case explains why no case has granted an injunction under Tutsa on the kind of inferences and speculations that Create AI offers here. It's also why Create AI has been unable to provide a single case that does what it's asking this court to do, reverse the denial of the Tutsa injunction. In fact, no case cited by any of the parties even reverses the denial of an injunction. Only one, State v. Holland, which is our case decided, which is a pure legal issue. non-elected. So this is how extraordinary of an ask they're making in this court. Having technology, even taking steps to protect technology, does not keep it secret or make a misappropriation claim under FEDPA. The same view case came out, and I think this is applicable here. If prior access to or knowledge of trade secrets were enough, it would lump all non-disclosure obligations into non-competing FEDPA. So providing actual access, evidence of actual access, is as important as providing evidence of actual trade secrets. I wanted to mention, we talked about braking, and we broke down the differences there and why they don't reveal identical systems. But also on steering, I would encourage the court to review the two exhibits side by side. These 132 and 136, both in volume 8 of the record, because those numbers are actually different if Judge Droge were to have dug into the record as they wanted to. So 20 milliseconds for latency compared to 15 milliseconds. 1160 degrees for range compared to 1008.
But we're talking milliseconds. Like that's,
And for use, the cases require identical products. So this harkens back to the Fowler case in which Judge Strummer commented that he was doing such a claim, he denied it. Because at most, the plaintiff had only shown that they occupy the same commercial niche, perform the same general functions, and his words were, it's like a Ford Pinto and a McLaren 620R. They both move people place to place. Both of these trucks move themselves, but the systems are different. And Dr. Ho testified extensively, I believe, for the entire first day about the differences. So they argue that the details are exact, they're wrong, the details are actually different, and they point to different systems. But the larger point is that judges look at the role within their discretion to deny the injunction. Same with semantics. This is Exhibit 73 and Exhibit 55 in Volume 8 of the record.
is that the red light and
Yes, this is the semantics regime. So Mr. Liu testified that all autonomous trucking systems use semantic regimes to basically label problems and correctly face them. He testified that, in fact, all companies probably have one called quote pedestrian crossing the road. And those two exhibits are one example of the semantics or the words that these companies use to categorize problems. And so there's a list of, I think, 20 different categories of Create AI use. None of them appear in the other documents. There's no evidence that they're using this semantics. And the words red case and
Right.
green case are not a trade secret. That's terminology used in the industry. We still do not specify those as a trade secret. Green case refers to when there's a liability-free action that the truck can take. Red case refers to if the liability was more ill-defined. Those are not trade secrets, and there's no evidence of that. They want the court to infer use based on audit success, and that's what the CAE case categorically rejected. To infer similarity or threatened use, there must be substantial similarity between the products at issue. Finally, there's no evidence that Create AI faces a threat of probable, imminent, and irreparable injury. The third and final requirement for any injunction. The Texas Supreme Court has made clear for decades, each element of injunctive relief must be pled and proven, including the last one, to examine the likelihood that a plaintiff will face imminent and irreparable harm.
Do you agree with opposing counsel that there's a presumption here?
I agree there is a presumption from some Texas intermediate court of appeals cases, most of them predate TESA. I don't think you get there here because they don't need prongs 1 and 2 stating a claim and including probable right to brief on that claim. But even if the court were to choose to apply that presumption here, they don't need the standard used in those cases. We'll look at TNT and Bell Helicopter there. There was actual evidence that a competitor had actual access to actionable trade secrets. So harm is not probable, harm is not imminent, and harm is not irreparable. That's why Create AI has instead chosen to rely exclusively. I don't think they briefed or argued in their opening brief that they could even meet this harm element as an evidentiary matter. They rely exclusively on the presumption because they can't meet the element of harm. But under Texas law, you must satisfy all three elements. Even if this court were to choose to adopt and apply the presumption of harm, it's not warranted because there's no evidence that the competitor had actual access to actionable trade secrets. And regardless, as we discussed earlier, it's a rebuttable presumption, and Judge Droge would have been well within his discretion to find it rebutted by their pivot from AV manufacturing to video games. And beyond the merits and irreparable harm, Create AI is seeking an equitable remedy, and in balancing the equities on audit is the only party to put on evidence that it would face a threat of probable imminent and irreparable harm. To be forced to subject to an injunction that would have ended its entire business before it could begin. In conclusion, we just ask that this case will be reviewed with the proper standard of deference and not going to common sense standards. Thank you.
Thank you.
Thank you, and may it please the court. Several things to address. First, there is an issue of law where I think the court could really help us out, and it remains relevant in the proceedings in the trial court now. So even if this court affirms, I think some guidance on the argument my friend was making regarding the interplay between patent and trade secrets might be helpful here. They have insisted that it is our burden to disentangle patents from trade secrets. Unfortunately for them, the Fifth Circuit says otherwise. In an undisturbed 2013 case cited in our reply brief, WellLogic v. Accenture LLP, 716 F3rd 867, 2013 Fifth Circuit case. This is black letter Fifth Circuit law that if they want to argue disclosure of a trade secret via a patent, it is their burden to show that. And the exact quote from the Fifth Circuit is, quote, "A patent destroys the secrecy necessary to maintain a trade secret only when the patent and the trade secret both cover the same subject matter." The Fifth Circuit goes on to impose the burden to show that the patent has disclosed the trade secret on the plaintiff asserting that affirmative defense. So it would be wonderful if this court would give us some guidance on whether WellLogic is still good law or not. The U.S. Supreme Court hasn't disturbed it, nor has the en banc Fifth Circuit. Under the Fifth Circuit's rule of orderliness, I think that makes it still good law. Second, my friends on the other side are just wrong about the presentation of the braking system evidence to the trial court. That was a big part of Mr. McCarthy's closing argument at the end of the day-and-a-half temporary injunction hearing. He made the same document comparison that I've offered to this panel. And then we reiterated that in some post-hearing briefing. So that very much is in the record and is urged below. What was not urged below is this business about a failure to properly identify trade secrets. That's a pleading defect. There was no Rule 91A motion to dismiss filed to challenge the pleadings in this case, and I think you will find the record of the TI proceeding devoid of this, quote, reasonable particularity argument. That is a new argument that was not urged at the TI that they came up with months later, and I don't think it's properly part of this appeal of the TI.
Can you help me on the irreparable harm?
Yeah.
So I'm assuming you're correct that, so what we're supposed to do there is balance the equities and balance the harm to your client if there's not a temporary injunction, and the harm not just to them, but to the public and public interest if there is one. So now I understand the argument. The company that he did work for has switched to gaming. I understand there's another apparently affiliate or something like that's proceeding with Asian autonomous trucks. But I've never seen a public interest case and temporary injunction that took into account the interest of the Chinese or the Japanese. In a lot of ways, those are our competitors. And the American public, we're better off if we're making those things, rather than just like fracking, just like AI itself, we're better off and our economy's richer and everybody's better off. We employ more lawyers. If we make that here and they are working on making it here and you're not, so how do we say that balance of the harms is in favor of you who are not making them here anymore?
Well, Your Honor, I think part of the balance of the harms would be the modest nature of the temporary injunction relief that's been requested here, where we're asking not to prevent them from using the purported trade secrets during the pendency of this litigation. We're asking them not to disseminate or transfer those secrets. That's
It's okay that you took our trade secrets and it's okay that you use them, but you just can't tell anybody that you're using them?
We
Or-
don't want to lose the trade secret protection that public disclosure would cause. We're going to get a merits adjudication on whether they've taken our trade secret or not. And we can wait for that day with them. But if they give it to third parties or anyone else, then we have lost our trade secret protection as against the world.
As have they, if they give it to somebody else.
That is true, but I have no control over what they do unless there's an injunction preventing them from transferring or disseminating our trade secret material. I see my time is up, Your Honor.
Well, you can have an extra minute.
Your Honor, this is the least ambitious injunction that I've ever seen. So it is, you have our information because you have our former CEO, founder, Chief Technology Officer. You also have our Chief Technologist. You also have several dozen of our technology side employees. Don't use our stuff. We'll get our merits adjudication down the road. Excuse me, don't use our stuff, but use it confidentially until we get that merits adjudication. That's all we're asking for here. And that is a reasonable request when you look at this mountain of circumstantial evidence. There is no requirement for direct evidence. There is no requirement for a smoking gun. The trial court abused its discretion by refusing to accept a mountain of circumstantial evidence. Thank you.
Thank you very much, counsel. The case will be submitted. We'll take another and the final 5 or 10 minute break.
All right.
We'll argue that one. Well done. Really? Congratulations. Well, that's what a great day. Okay, well, congratulations.
No, not at all. Good luck to you, by the way. We'll give you a fresh water. Oh, we got it. Oh, I mean, you know the justices. You should.
I'm Gabrielle.
No, you're fine. Everything was very close. Right? Yeah, I'm like, they're over here, they're over here.
Apologizing in advance. I know it, and I'm trying to keep it in the best I can.
Yeah, can you hear me okay? Okay. Yeah, no worries.
Be seated, please. Thank you for sticking with us to the bitter end. Court calls Crinus versus ES3 Minerals. Who's present for the appellant?
Gabrielle Smith, Your Honor.
Welcome. And for the defendant, for the appellate.
Ryan Chapman, editor.
Welcome. Good to see you. Ms. Smith.
Thank you, Your Honor. And I would be remiss if I didn't start out by saying howdy as a proud Texas Aggie. Good afternoon, and may it please the
But we
court.
didn't respond. That's so wrong.
I know.
Wow.
I'll excuse it today. Good afternoon, and may it please the court. Gabrielle Smith here for appellants Nicholas Crinus, David Ryan, and their affiliated entities. And I want to do a few things this afternoon. I'm not going to rehash all of our briefing. There's a lot, I know, because I had to reread it. But I want to hit on a few points. And I think to start, I want to explain kind of the industry that we're talking about here and the restraints, kind of how we wound up in this court. I think, Justice Pfister, you alluded to it. We've been in front of a few different courts on this injunction, and then explain why this injunction should be vacated. And so this is a case that is not about investment, but about entitlement. These players, both ES3 Minerals as well as my clients, are involved in the mineral brokerage industry. So they're buying and selling mineral interests. And this is not a complicated business. I think it's been said, and I think it's in the injunction record, that this is simple but not easy. It involves a lot of cold calling. And if anyone who's ever had a sales job, I know I have, it's not a lot of fun, but it's not hard. And so you're making cold calls to mineral interest owners. And the way you find these mineral interest owners' identities is through the tax records. It's, I can log on right now to the tax appraisal website and pull Excel spreadsheets or CSV files and get a list of all the tax owners. And that's what's being used to make these cold calls. It's from public records. And that's important here because there's a lot of testimony about, well, this is mine, this is what I've done, but it's not about what ES3 Minerals has done or has invested. These are matters of public record.
So I agree with you on the trade secrets. It looks like something, old days. If you get the information of potential contacts from Yellow Pages, it couldn't be a trade secret. There's no Yellow Pages anymore, but you can get a lot of information off the internet. But these guys did sign a non-competition and non-solicitation agreements, and that's different. That's if you agree not to compete, you agree not to compete, not using secret stuff or still using secret stuff, right?
So, Your Honor, I will say a few different things on that because, first of all, I represent multiple appellants here. And I think that's important because there are facts that are a little bit different as to each, but they've also been treated, as to one, as to all. And so I'll start with Mr. Ryan. David Ryan started at ES3 in 2018. He left to return to the semiconductor industry in February of 2021, but then came back to ES3 in April of 2021. So he was just gone for a couple of months. And ES3 has said, well, that absence doesn't count. But it does count because it was a solid break in his employment with ES3.
And he did not sign a new non-compete on his return, right?
He did not, Justice Ferris. And that's exactly right. And so when you look at the agreement that Mr. Ryan signed, it states that the restrictive covenants are for the term of his employment and then begin running for 24 months after the employment terminates for any reason. And so his employment terminated in February of 2021. So 24 months after that is February 2023. There has been no allegation in this record or even since then that Mr. Ryan did not have a break in his employment. If there's a break in his employment, then those restrictive covenants have long since run. And any competitive activity, let's say, happened well after February of 2023. And so as to Mr. Ryan, even if I conceded that was an enforceable agreement, which I do not, but even if I did, Mr. Ryan's restrictive covenants ran out just as a matter of clock. And so as to, and Mr. Ryan, and that's important because Mr. Ryan is the principal of CGR, one of the defendant entities, and LMP. And so, which is the primary business entity here that ES3 alleges is competing against it. It's Mr. Ryan's company. And so if Mr. Ryan's restrictions didn't exist, then you can't restrain LMP.
Could I hate to break up your train of thought here because I do think these are very significant issues. What do we do about the standard of review here? We're kind of in a weird situation where one court heard the evidence and then it came to the business court, which did not, rehear evidence. Like, are we limited to, do you have to show a change of circumstances for us to do anything? Does the court get abuse of discretion review when the court that, signed the most recent order isn't the court that actually heard evidence? Like, what do we do from a legal perspective? How do we handle this?
Yes, Your Honor. And it is our understanding that it's still an abuse of discretion review, even looking at the modified temporary injunction order. Because and this gets to kind of how we got here, right? So we had the temporary injunction hearing before Judge Iserloh and the Travis County District Court. This case was removed to business court in December, right before Christmas. And shortly after it was removed, we moved to dissolve, which is a little bit different than this appeal here. And that's important because the court's order on the modification was kind of as that motion to dissolve, understanding that the court was aware that this appeal was happening as well, and that the Court of Appeals would ultimately get to review the full scope of the errors here. And so the modified temporary injunction order looks a whole lot like the original order that Judge Iserloh signed in November of 2024. And I think that's important because we didn't have a new hearing. There was no new evidence presented. It was kind of the very first introduction that this case had in the business court. And if you look at the reasoned opinion that accompanied the modified order that Judge Sweden issued from the business court, it does basically say that it's, not that it's a rubber stamp of what Judge Iserloh did, but that there was a lot of deference given to what Judge Iserloh wrote in her order. And so there weren't like new findings. There wasn't new evidence presented. It is a sort of initial review, but it is not a full review that robs this court of the standard review here.
Did anybody ask to be dismissed because it's a different court now, we got to start over?
Did anyone ask for judicial notice of the record from Judge Iserloh's court?
The record was provided to the court. We didn't know that we specifically asked for judicial notice in the motion for review.
Yeah,
But
it just
but
became
yeah,
a
it was,
record.
and I know Judge Sweeten did have access and reviewed that record. So
And could I ask you to cover one other thing?
Yeah, absolutely.
And then, so there's a lack of case law on this proportionality question. If it is okay to, have an injunction, then there's a bond. And there's a difference between nominal, which, I see nominal as like $1. But then there's, a wide spectrum of numbers that it could be. And there's not a lot of case law on this. This is an underdeveloped area of the law. What would you suggest in terms of if we reach that issue on proportionality, what should we write?
absolutely, Your Honor. And you're right. This is, and I think you can see it from the briefing and from your own research, that this is a wonderfully undeveloped area of the law.
Which we love.
So exciting for you.
Make our living.
But as to the issue of proportionality, and I want to give a little more context. I know, we have the $1 example, but here, to put it in perspective, when we look at the evidence of what the bond should be, the evidence that was presented both at the temporary injunction hearing and in the parties' closing brief submitted after the hearing. The bond that was issued was a $25,000 bond. And while that might sound at first blush like a healthy amount, it's really not when we think about the scope of the evidence that was actually presented in this case. And hopefully you'll ask my friend, Mr. Clinton, here about, the evidence of that $25,000. If you hear it, that'll be the first time I hear it too. Because what we heard and what we read in the record is ES3 saying a $400,000 bond is what ES3 put forth. Appellants put forth a bond, I would say, a little south of $4 million to also start looking at revenues of about $20 million.
Is this something that you would have to get an expert in to testify about, like what measure of damages we should be looking at, what the damages are? Is that something you've got to have expert testimony at this juncture, or not necessarily?
Not at the temporary injunction phase,
Okay.
at the ultimate trial of the merits. I think, yes,
Okay.
we are talking about expert testimony as far as the damages issues.
Sure.
But at the temporary injunction phase, and I think that's important because the evidence that's presented is probably in a range of between $400,000 looking at ES3 and in maybe $4 to $20 million looking at appellants. But you don't hear it's 25,000. And just because probably my engineering family would get mad at me if I didn't use the numbers, I want you, $25,000 is about 6.25% of 400,000. And so when we're talking about nominal, I think the word I'd rather use is a token bond. This is a token bond because it's 6% of even the lowest number that is in the record.
Like y'all wouldn't be here today if you were just fighting about $25,000, right?
We would not. That wouldn't be a good use of my trip to Fort Worth. And so I think that is important in terms of the proportionality, because there might be cases where it's a close call. This is not one where we're talking about 6% of the lowest number of the party trying to get an injunction and pay as little as possible, 6% of their number.
Mhm.
That's not 6% of the number of the revenues here for folks who are restrained from doing lawful business, but still have to pay employees, still have to figure out how to try to generate revenue in the face of restraints that involve public data, involve buyers who are actively advertising in a space where relationships and building those relationships and soliciting new business is how each of these people makes their money. So they're being restrained from the use of everyday common data, but but the restraints are real. And there's the issues here, and the lack of specificity and the overreach here really has constitutional underpinnings. And I don't want to jump around too much, Your Honor. But I think that
Before you get there,
yes.
I haven't seen a case on this, but you may know of one. The non-competition agreement or the business agreement, so to speak. I know you could separate Mr. Ryan, but let's put that aside for a second. It talks about the assumption that monetary damages would be inadequate and that injunctive relief is appropriate if there's been a breach. Is agreeing to that ahead of time in a contract enough?
I will tell you that I don't know that I have a ready case for you on that. What I will say is here we do have testimony in the record about dollars at issue here, about disgorgement, about monetary damages. And I think this goes to the fact that ES3, in order to have gotten this injunction, should have showed imminent and irreparable harm. If I can cut you a check, then that's not irreparable. That doesn't warrant extraordinary relief.
But if you agree ahead of time that it's irreparable and that monetary damages aren't an issue, I didn't see anyone really raise this, but the contract says it. So just kind of a freedom of contract principles, is that enough that suddenly whether you could be compensated for this doesn't matter anymore?
I think it does not matter here where the agreement is not otherwise enforceable. I mean, I think that if we're talking about an enforceable agreement, I don't know that I have a ready case on that. But here, I mean, I think that there are other issues with the actual provisions of the agreement that nullify that.
Do we have to assume that from the record? Because we don't have that ruling, right? That it's unenforceable, or do we?
We do not have that ruling.
That's what I thought. So if we don't have a ruling it's unenforceable, don't we have to give credence to the contract's language?
Well, I will tell you, there's also not a finding about that in the record or in this order. And I think that's important. I think that the lack of specificity, the lack of clarity of how we get to these numbers, how we get to the fact that this extraordinary relief is appropriate is important, because that the absence of that in the record and frankly in the order is consistent with the absence of kind of the factual reasons throughout this order for why these folks should be enjoined and how and what they're enjoined from. There's a lot of conclusory language, but there's not a lot of factual reasons, not just as to the how, but as to the why, and why this is irreparable harm. And that's, again, that's not in the record, that's on the order.
I'm gonna let you off the hook. I just, because I'm curious, I mean, in some ways the contract could have been, we don't know, because we don't have findings on it, but the contract theoretically could have been the reason there was not more specificity, because it had been agreed to ahead of time.
Well, we could divine a lot of things of what could be, but but again, if we're talking about injunctive, and this is extraordinary relief that comes with extraordinary compliance, if we're having to divine and try to infer about what it is, that's exactly why this injunction fails.
Yeah.
So, before I dive into anything else, I would just ask that the court reverse and vacate or dissolve this injunction, and happy to answer any other questions on rebuttal.
Thank you, Ms. Smith.
Thank you.
Mr. Flint?
May it please the court. It is an honor to be here today before you. I think this is the third court in which, appellate court in which I have appeared before Chief Justice Brister, and that is an honor.
Keep moving around.
It's also an honor to be before the students today. Please send your resumes in to all of our firms. We appreciate the opportunity to be here very much. Justice Field, there is a case cited in our brief. It's the Wright case for that proposition, Wright versus Sports Supply Group, Inc., 137 Southwest 3rd, 289 at 293, is a case in which the court pointed to the fact that there was an agreement, a pre-agreement, that a breach of the contract would be irreparable harm. Before we talk about, though, what was presented, I think it's important to talk about what's no longer before the court and what isn't before the court. The temporary injunction with respect to Ryan expired in August There's nothing, there's no temporary injunction before the court with respect to Ryan. It's gone. It's moved. It's behind us. Appellant's argument in their opening brief that on the prohibited contact not being descriptive enough was targeted towards one sentence. They actually said in their appellant's brief, the remainder is complete and accurate and obvious and good, but there's this one stray sentence which causes a problem. In the modified temporary order, that sentence was taken out. It was a mistake. It was a Scrivener's error, and it was removed. So their issue with respect to the specificity of the buyer's list is also moot. In addition to that, there were multiple grounds of the trial court's temporary injunction. There are multiple findings with respect to the temporary injunction on multiple claims. And the only findings that were appealed to this court were the findings on the non-compete, which was only 1/3 of the agreement of the parties, and on the Uniform Trade Secrets Act, but we also had a separate claim for breach of the confidentiality agreement. Confidentiality agreement, by the way, does not have a 24-month expiration date on it, so that would continue beyond. So we have lots of findings that the trial court made that go to the temporary injunction that were not challenged on appeal. So it's our position that the court needn't even reach the issues presented with respect to the substance, because there were all those other findings on all of those other claims that were not challenged in the opening brief. Now, we briefed them in our response brief, and therefore they replied to them in their reply, but it's too late at that time to challenge the trial court's findings.
Putting aside real quick, I know your last point, you could argue moots this question, but just indulge me. On the definition of buyer that was modified, it still requires the person enjoined. It depends on their knowledge. How do we enforce that? I mean, how do in reality you have a go back to the trial court and you try to enforce that? How do you do it? I mean, doesn't that make it a bit vague?
No, and the reason for that, Your Honor, is there are some areas of this law where we do have Texas Supreme Court precedent. And we don't have to make up the law with respect to this case. And the closest case we can get to that is Ex parte Chambers in the Texas Supreme Court, 898 Southwest 2nd, 257. In that case, the court ordered that a company pay a fine, a contempt fine. And the only officer of the company says, hey, I don't have to pay it because it doesn't say me. And the Texas Supreme Court said, no, that's a ridiculous argument. You can't just say that because you're near them, but not technically the named party, that it's no good. The court says specifically, the order need not be full of superfluous terms and specifications adequate to counter any flight of fancy a contempt nor may imagine in order to declare it vague. In the second Texas Supreme Court case is even more helpful in its description of what it has to say. And that is San Antonio Bar Association versus Guardian Abstract and Title. That's 291 Southwest 2nd at 697. And there, the court is talking about how specific does it have to be. The court says, obviously, an injunction must be broad enough in terms to prevent repetition of the evil sought to be stopped, whether the repetition be in the form identical to that employed during the injunction, prior to the injunction, or, and the court says, what is more likely, in somewhat different form calculated to circumvent the injunction as written. Now, the only thing that the order says is you can't use a subsidiary. And the reason for that makes perfect sense because a subsidiary is the prime, right? So the order already says you can't contact the prime. The order didn't have to say. In fact, it is less restrictive. They got more process, not less than they could have. Because it says not only can you, it's not just subsidiary, it's subsidiary that you know. It is a narrow constriction of the restriction. And so it could have simply said the company, and that would have been enough because under the Texas Supreme Court precedent, it doesn't have to say everything. It's a reasonable restriction. So that does answer the with respect to the conduct. The appellants made in their brief, but not today, a large argument that the reasons weren't specified for the harm, and that's simply untrue. It's a 7-page temporary injunction. It's one of the most detailed temporary injunctions that I've seen. And again, we can look to the Texas Supreme Court. We don't have to make up law here. The most on-point case is Transport Company of Texas versus Robertson Transports, Inc. 261 Southwest 2nd, 549. There, all the injunction said with respect to harm is it would interfere if we didn't ban these tank trucks with bulk chemicals in them, that it would interfere with the markets established and would probably divert freight and tonnage such that it would interfere with customers and markets.
Well,
the text-
here, I mean, that to me seems like a little bit of a different scenario because of what is protected. But here, to me, it seems like where the, like, for example, the client list is something that could just be pulled from, public property records. It seems to me like maybe a little bit more of an explanation is due for why there would be irreparable harm for essentially kind of going to the phone book.
Well, so the going to the phone book thing was grossly untrue.
Okay.
I work in, most of my
Yeah.
clients are in this industry. You can't simply go into the phone book and figure out who's going to buy
Mhm.
hundreds of of dollars worth of minerals without seeing the deeds,
Right.
trusting you. Also, the buyer's list, I want to be very, very specific here. What we're talking about is our buyers list, not a list of theoretical buyers in the market. We're talking about the ones who have come to us, the ones who have trusted us, the ones who are comfortable with this essentially high-speed trading arrangement of minerals. High dollars, high speed based on trust. They're our buyers.
And that wouldn't be something that just shows up generally in the property record.
Exactly right. You can't just Google who are our buyers. Second, very important,
Right.
this buyers list was not, in their brief, they act like the buyers list was limited to the name of the buyers. It's not true. The buyers list was unfortunately used as a term to mean more than that. It was the identity of our buyers. It was their preferences. It was the past sales information with respect to all of them. So it was a whole lot of information that both parties testified at the temporary injunction hearing is in fact very valuable, and you would want to keep it confidential. Because Google is $1 trillion company because, for the main reason, is that it is determined buyer preferences. That it is a way to get to determine buyer preferences. Well, we have that, and they took it. Unlike the last case that you heard today, there were lots of smoking guns here. This is not a circumstantial evidence case. They actually began forwarding their emails with our buyers' information to their own private email accounts while they were working for us. They downloaded thousands of pages of our proprietary confidential information, including the prices that we sold to and the buyers. They downloaded it to a Dropbox and then used it. They actually began working deals while Primus was still at our job, negotiated an AMI agreement on behalf of one of LMP's, on behalf of LMP while working for us. Actually helped LMP close a sale to one of our buyers with our information. It's on videotape. They actually videotape themselves using our information to sell to one of our buyers.
So I think that brings me to a follow-up question that it does sound like this isn't just phone book information. It does potentially sound like there's something very valuable here.
Correct.
But if that's the case, why is $25,000 enough?
The question on appeal on a bond is not what evidence is in the record to justify the amount of the bond. The question on appeal with respect to a temporary injunction bond is what evidence in the record can you show conclusively establishes a different number? And there is no evidence in this record to do that because they didn't bother to do it at the temporary injunction hearing. What they showed us was their past profit margin and their past profits on different contracts. And then a month later, they added a declaration that said, we project this much amount of income. Every court that has ever looked at it, and we repeatedly say them, we've cited to many, many cases, and we cannot find a single one to the contrary, has said that evidence of lost income is not evidence of lost profit.
Well,
and
what do
therefore
we
wouldn't
do
support
with
a bond.
DeSantis, just kind of the basic principle, because DeSantis is, I guess, from 1990, Texas Supreme Court. It just kind of sets out the fundamental principle that the purpose of the bond is to protect the defendant from the harm that he may sustain during the injunction period. Wouldn't that imply that the bond amount should be proportionate, I guess?
Well, as I would say,
Uh-huh.
citing Justice Young's dissent to
Yeah.
the petition for review, which is, I think, probably where much of this comes from, he said, it says, proportionate to what? And there are cases when you know what the actual cost is. So if it was, for example, real estate, then you would know what the cost, you can know exactly what the cost of is. If it was $100 million being held in a bank account, you would know exactly what the cost is of the bond. And so in his, his out loud thinking, where he says, I'm not even holding myself to this opinion, I'm just bringing this up because it's an interesting question. He says, proportionate to what? The problem is they don't have the what in the record because they don't tell us what the actual lost profits would be. Now, they asked the court in the reply brief to perform some calculations, saying, well, you can take our profit margin from our old contracts and apply that to what we said was our projected income from our new contracts, and you can run the calculations yourself. But there was a case exactly on point of that, University General Hospital LP versus Prexis, where the court says, if you want to take old, that's 403 Southwest 3rd 547, if you want to take old revenue, old profits and apply them to new contracts, you actually have to do the work to show that they're the same type of contracts and you would get the same amount of profit. We can't do it the courts are not going to do it for you. You actually have to do it, and you have to link the information together, which they didn't do. They didn't say you can base those, our future income based on the same profit margin because, the contracts are the same. This is what the court said there. There was no evidence that the contract upon which the profit margin was based was sufficiently similar to the contracts upon which lost profits was projected. The profit margin on one contract cannot serve as a basis for the required single complete calculation of lost profits.
So
from other
basically,
contracts.
would it be your position that to be able to get a substantially higher bond than 400,000 or the millions, that you would need an expert at this early stage to come in and run numbers? Or-
I don't know the answer to whether it has to be expert testimony, but you certainly have to you have to have evidence, right? You have to have some evidence that links it. Again, we're on an abusive discretion standard. They're the ones that have to show that the trial court did more than just err, but had no reasonable basis for the opinion. And they're the one who had the burden, not us, to put evidence in the record to show a higher amount of the bond. I also want to say,
where does the lost profits though come in? Did they suggest that was their standard in the record? That because it seems like we're going from lost profits to cases law on lost profits, which is hard to prove. But it seemed like in their briefing, at least, their argument really is you're shutting our business down. It's revenue. We can't pay our employees. So where does the lost profits come from? Is that y'all's idea or is it their idea?
Lost profits is the test for damages. So it's the test for showing actual loss. Lost income, Texas Supreme Court, virtually every court in Texas has said lost income is not evidence of loss, because you would have to look at what you would have paid, what it would cost you for that. I do want to say
but
also,
is a bond amount and a damages amount, are those the same? Or is this a different standard?
the cases where the courts have looked at the bond amount look to lost profits. They don't
Is
look to lost
there-
income.
I know Maples looked at lost profits. Are there others like
Yes.
right?
Let's see. IAC Limited versus Bell Helicopter Textron, Maples versus Muscle Tech. Both of those look to that. Lamasse versus Sandoval, Top Heavy Studios versus Doe. So the four cases, all four of which say lost income is not enough. You have to show lost profits. I want to mention one thing. My friend on the other side said that we told the court we think it should be 400,000. That is sort of true. What we told the court is that they didn't prove any lost profits, but you can't do zero. So we said the court should do a nominal. We said alternatively, if they can prove that their salaries are 400,000, then 400,000 should be it. But they didn't put the proof in the record to set the bond. Last point I want to make on the bond is that the bond amount being too low is not a reason to strike the temporary injunction. It would have to be that there was no bond at all. That would make it. So what the remedy for that would be simply remanding. I think in this case, it's likely to be moot anyway. The second part of this moots in the beginning of January. So in large part, this case is going to be moot very, very soon. I do want to talk about, Justice Brister, you
So
said.
let's see, you're promising if we delay deciding this case for 3 months, we don't have to decide it.
I didn't say it, Your Honor. I want to say with respect to the trade secrets, Chief Justice Brister, you said, maybe I'm on your side with respect to trade secrets, but the Uniform Trade Secrets Act expressly lists among the things that can be protected a list of actual and potential customers. The Texas Supreme Court has said a trade secret is any formula, pattern, device, or compilation of information is used in one's business.
Of course, you mentioned the buyer side. Yes, you don't know which private equity out there is interested this week in
Correct.
in leases. But on the selling side, everybody knows these. That's what the whole top lease game is about. You find out who's not producing in paying quantities and who owns it and why not and why somebody hasn't been tracked. And so you would know part of the equation probably.
No,
With a lot of work.
You could
have to have a good landlord, but
and they do cold call, no doubt. I have gotten a cold call from one of these two parties. I won't name which one. But yeah, that's true. And that's why that's not protected in the temporary injunction. It's not
the buyer.
It's the buyers that were protected because that's the information that was our customers that we developed relationships with, that we developed the ability to high-speed trade minerals with at huge profits, at huge numbers. That was the special sauce of all of this, was the system that developed a high-speed mineral trading. And that's why it's so important that we be able to protect our trade secrets. But they don't have to be trade secrets. The court does not have to find them to be trade secrets to uphold the injunction because of the confidentiality agreement that has a lower standard. It doesn't have to meet the trade secrets definitions in statute because we have a confidentiality agreement that had the same requirements, and they couldn't, including specifically buyers list and buyers information. The findings that went to that claim were not challenged in appellant's brief, and so those findings are all there. With respect to harm, there are two things that that the court would have had to abuse its discretion about on harm, which I think goes to a lot of I think their briefing, whether it's irreparable or whether it's an eminent. And they say there's no evidence of eminent, but I think that's because they're not following the test of what eminent means. In Wynn versus Blanchard, this is a Texas Supreme Court case 694 Southwest 3rd 648. The court says that a finding of eminent harm can follow from a variety of circumstances, including actual injury, which is what happened here, or a pattern of actions, which we know here, or a threat to undertake harmful action. They're going to continue to use our buyers list so long as there's really no debate about it. Yes, they're going to continue to use our buyers. They're going to continue to use our information. They did so while they were still, at least what with Crinus was still working for us. The confidentiality agreement itself, the parties pre-stipulated, they agreed that a breach of this contract would in fact lead to a temporary injunction, and they agreed in advance that it would be irreparable and eminent harm. Irreparable means simply that it cannot be adequately compensated in damages or it's difficult to quantify. They, in their opening brief, make a big deal about how that we can only say that it was vibes. But that's because they're trying to create a false binary choice. They're trying to do this heads they win and tails we lose, which is they say, well, because you don't have specific lost sales, you lose. You can't get a temporary injunction. And then later they say, if you had evidence of lost sales, you couldn't get a temporary injunction because it would be compensable. And so they're in their world, there's no such thing as a temporary injunction. But here, when you take our stuff and you use it against us and you make tons of money from our customers with our customers list, that is irreparable harm. And goodwill and taking our employees, these are all things that courts have held are in fact evidence of irreparable harm. And I've seen no evidence of not.
Clarification, Mr. Frank, when you say moot, you mean temporary injunction. I assume you're still suing these people to get some of the profits or not?
The temporary injunction is moot. Yes, Your Honor. Thank you.
Ms. Smith.
Can confirm my clients are still being sued. And so I want to say a few things, but hopefully not talk too quickly. We're still talking about the standard review here.
Both of you get an amazing number of words in 20 minutes. I'm very impressed.
Thank you. I think it's important because we're talking about abuse of discretion. Discretion ends where the record ends. And when you look at the order, I think this goes back to lack of specificity. There's a lot of conclusions about, there's been a violation of goodwill. How? There's been a misappropriation of confidential information. How? Mr. Clinton talked about the documents on these folks' computers. Well, ES3 required them to use their personal computers, and so they're in the course of doing work for ES3, they had to use their personal computers to use ES3 documents. Now, a lot of those they got rid of. Some of them they just didn't go do a deep dive and find them. This is not some spy game. And in terms of they sent themselves emails, I want to be clear. The email that we're talking about in particular is an email sent 4 years before Mr. Kreines left. So that's an allegation that Mr. Kreines was planning to do something 4 years before he ever left, 4 years before he's ever talking to Mr. Ryan. And that's a lot of what we have here. And I know counsel tried to downplay the evidence of Vibes, but Vibes is the only evidence in the record. When you ask Mr. Stanton, the president of ES3, kind of, were there any relationships that were ended? Well, no. I just felt people were colder to me, or we're maybe not doing as many deals, but there's no evidence in the record of the number of acquisitions because it is a two-pronged business, right? There's the acquisitions and there's the divestitures. You can't sell what you didn't acquire. And there's no evidence about what happens on the acquisition side. There's a lot about talking about the buyer side. And as far as, it's not just a phone book. I have a few things to say on that. First, there are directories that include the names of these entities, the names of these contact persons, and preferences that, we prefer deals in the 5 million range. We buy in the Permian. And so there are kind of, for lack of a better term, phone books. There are these directories. I can tell you because I've gone online and downloaded it myself.
So did they explain how they found the buyers that they did find?
Well, and they didn't explain this, and there's a lot of talk about our buyer list, but the record evidence isn't a compilation that ES3 put together. They're Mr. Kreines' work
No,
papers.
I'm sorry, I was asking, so your guys did some deals, they made a ton of money. Did they explain why those, was it just a coincidence that this was people on their buyers list or something?
Well, these are people that Mr. Kreines did have relationships with. That's true. But I want to be clear, these are not ES3 buyers. That implies exclusivity and entitlement that does not exist here. These buyers do deals with L&P, with ES3, and with a number of other brokers. So they're not ES3 buyers. They've done deals with others, and they are identifiable from the records and from the public records like deeds, but not just that. They are advertising in these directories.
So are you arguing that their buyers list is basically everybody in the world? There's nobody else they could possibly sell to?
Well, I think the buyers list is important because the buyers list that's attached to the temporary injunction is not a list that exists otherwise in the record. And so that list was compiled for purposes of the temporary injunction. Once Judge Iserloh indicated that she was inclined to grant an injunction, ES3 compiled a list, and that's what's attached to the order. The buyers list that is in the record are Mr. Kreines' work papers. There's no compilation otherwise at ES3. There's buyer information that exists in different pockets around ES3, but that goes again back to, this is a case about entitlement versus investment. There was no investment of time in compiling this sort of trade secret buyer list until this injunction. And so there's not this buyer list to be stolen. The fact that there are deals with entities that have done business with ES3, but they've also done business with a number of other entities as well. And there's been no indication that any of these entities are doing business with L&P or anyone else in lieu of doing business with ES3. And finally, there's still the note of as to one, as to all. There was discussion about things that happened while Mr. Kreines was still employed, but a lot of that, but a lot of what you didn't hear was the deals that L&P was doing and the acquisition of that interest had nothing to do with Mr. Kreines. Mr. Kreines was employed. He's talking to Mr. Ryan. They're good friends, but there's a conflating of, well, L&P broadly is doing this, but Mr. Kreines is not an employee of L&P, and Mr. Kreines had nothing to do with acquiring that deal, but they're conflating, again, all of these individuals together. And that's, again, why this injunction is not moot, because when you look at the temporary injunction order, and I see I'm almost out of time, the L&P restrictions are as to the determination dates of both Kreines and Ryan, again, conflating everyone. And so, again, all of these are are kind of mushed together, for lack of a better term. And so you have an order that is unclear, unspecific, and secured by a token bond. And so the court should dissolve this injunction for those reasons. And we did address, I know I didn't have as much time as I would have wanted today to address some of I know. I'm not unique, just like this list is not unique. But I will just say that I think that it's well spelled out in our brief why the other areas of lack of specificity. And so with that, I would just ask the court to reverse and dissolve this order.
Thank you, counsel. Case will be submitted. Marshal will adjourn the court.
All rise. 50th Appeals now stands adjourned.
We will be back in 2 or 3 minutes, and any of you have questions or comments, we'll be happy to hear them. Thank you, counsel.
Thank you.
Thank you all for attending. Remember, after the Q&A session, you sign the rosters out.
I actually So get you on Austin. So this is my second time before these folks, and both of the times in a law school, which is a really cool experience. Chambers and not chambers, we were like the gallery and all this stuff. There's a lot of gallery, but I like being but yeah, I mean, it was on my way. Likewise. So what are your I would say so actually I just keep more sure out there.
Yes. Yes.
Either one. Howdy. There you go.
Much better response. Likewise.
Hey, it was,
So you go first. Anybody, any questions? Ask Scott Stone and Maple Terrace. They'll give you the answer.
So,
Yeah, I was just gonna ask Chief Justice Mr. in the second case for all heard when you talked to the appellate attorney. Part of your questioning was on what might be better for the public, talked about truck safety and technology. So how does that weigh into your decisions as far as, what might be best for the general public?
Well, there's two interesting factors about non-competition cases and temporary injunction. Non-competition cases is, I think, the only area of the law where the rules and the law specifically orders the judge to amend the contract, or rewrite the contract. If it's too broad, if it doesn't have geographical restrictions, stuff like that, statute says the judge just rewrites it. That's, in this day of text revision, that is very unusual. But the deal is, employees fill these things up and they tend to blow them up saying, you can't work anywhere forever. And we don't want that. But it's a very fact specific, which used to be actually some of these cases on head and that's what all you mostly ladies, maybe men too, they all leave when the hairdresser leaves, and then there's a non-competition case. But how much time does this particular salon need to protect itself and lose all of its time? That varies on that. And it's just different inflation. it's kind of in flux, and I think, Jim Harris, has some strong opinions on that. He shared only with us, maybe he could share some with you, but it used to be, for 60 years, all my career, we just preserving the status quo is always there. And literally 2 years ago, the Supreme Court says, forget about that, because that doesn't give us any good, because any smart lawyer can say the status quo is, you just, it's the status quo ante. Well, what is the ante? Well, whichever one favors me. And so the new deal is this, who's probably going to win a trial, which is uncomfortable because whatever law, and then we enjoy somebody from doing something that we shouldn't. And then the other thing is balancing arms, and it is equity. And in equity, you always consider public interest. And so one of the things, just it's putting in this case, this what's so odd about this case, that case is that they're not in the business anymore. They are in the business in China, and so is that, does the public interest well?